So good morning, everyone. My name is Eleni Kosta. I'm a professor of technology law and human rights at the University of Tilburg, and I'm very happy to moderate today's academic session, the first academic session of this morning, where we have three speakers. We are going to have a presentation of 15 minutes each, and then I will allow for one or two questions on the paper. And in the end of the panel, we will have a more general open discussion where you can address any panelists. I just want to make sure that everybody gets sufficient time to get questions. If you have a question, I would like to welcome you to use the microphone in the middle of the room. Without further ado, I would like to give the floor to Amir Cahane, who is a PhD student, Cahane, right? Who is a PhD student in the Faculty of Law at the Hebrew University of Jerusalem, where he's research fellow in the third generation Digital Human Rights Research Project and a research fellow in the Federman Cybersecurity Research Center, the Cyber Law Program. He also serves as a researcher in the Israel Democracy Institute, and he has published already 2 books on online surveillance laws, both in Hebrew. Yeah. So the floor is yours. You have 15 minutes, and I will be keeping the time.
Thank you. Can I have the... So during the early stages of the coronavirus first wave and onwards, Israel has repurposed its mass surveillance collection program, metadata collection program, known as the tool, repurposed it for contact tracing purposes. The tool is normally operated by the ISA, also known as Israel Security Agency, Shabak, Shin Bet, GSS, depends on your sources. It's normally used for counterterrorism and counter-espionage purposes. In my paper, Creeping On, Israel's Turn to Counterterrorism Measures During the Pandemic, aims to outline several dimensions of creep that manifested in this repurposing of a national security mass surveillance measure for epidemiological purposes. And during this, I argue that these occurrences of creep are still echoed in ongoing Israeli efforts to adopt new surveillance technologies, especially in connection with law enforcement. These dimensions include function creep, purpose creep, and authorization creep, on which I will elaborate. Okay. So the literature tends to use the terms function creep and purpose creep kind of interchangeably, under a certain impression that we all are familiar with the terms and no need for some sort of a robust definition. When we're talking about IT and databases in particular, function creep is commonly used to describe a situation in which technologies or databases are used for purposes other than those originally intended by their designer. And this conceptual demarcation between function creep and, between purpose and function is complex, especially when the subject of this concept is technological. And when we're talking about technological subject matters, the function is usually the purpose, and things tend to intermingle. So to clarify things, I will use purpose creep to refer to a shift in the legal purpose of a certain technology, while function creep will generally refer to a shift in the technical functionality of a certain technology. Of course, these definitions are not robust and are subject to granularity of interpretation. In addition to function and purpose, there are other creeps that you may be familiar with: surveillance creep, mission creep, intelligence creep. All of these terms basically denote a gradual process in which is usually undetectable, which in technology or an activity slowly expands its domain. And I suggest to consider creep as a vector. It's a movement in a certain direction. Function creep or purpose creep may be from the military national security domain into the civilian sphere, and vice versa. It could be from private entities to public authorities, and vice versa. For example, when you're talking about a creep in the connection of in connection with contact tracing. Usually the concerns are of creep from of location data creeping from the civilian sphere after being collected by apps into the more security sphere to the hands of public authorities. In the context of COVID-19, some of these concerns actualized. Location data from contact tracing apps eventually found its way to law authorities law enforcement agencies in Australia, Singapore, and Germany. However, these concerns are reversed in the Israeli contact tracing solution. The creep vector has reversed. The concern is now from use of data acquired for national security purposes, which usually justifies more intrusive measures for purposes different altogether. And let's consider this reversal. So, the Israeli public first learned about the tool from a televised statement by the Prime Minister, which declared that the government intends to use counterterrorism surveillance measures to fight the spread of the coronavirus. An expose published several days later described an ISA database siphoning the entire Israeli metadata the entire Israeli communications metadata for nearly 2 decades. The tool legal basis is a very short, lean paragraph section in the ISA law, under which it may collect all types of metadata, that is anything that is not content data, compared, for example, with Section 215 of the Patriot Act. And the external oversight of the tool is weak. There's no ex-ante judicial authorization required. There's poorly informed parliamentary oversight, and no public statistics available as to its activities. It is governed by rules that are classified. So to the best of our knowledge, there's no limitation or no known temporal limitation as to data retention. And its geolocation analysis capabilities are basically triangulation of signals received by different cell towers. Perhaps additional communication metadata is used for heuristics to accelerate processing or to enhance accuracy. And in this respect, the tool is an occurrence of function creep par excellence, as data whose original design purpose was to technically support digital communications or customer billing or whatever it is, legitimate business purposes, is now harvested by a third party and processed to create a new data type, geolocation, for national security related purposes. In order to address the first wave of COVID-19 pandemic, the Israeli government required measures to monitor its spread and contain it. So during the first weeks of the pandemic, the Ministry of Health relied on a more traditional techniques of in-person, face-to-face investigations. Sometimes it was coupled with some manual examination of digital evidence, similar to what we've seen in South Korea, but it still was very manual face-to-face experience. And because of what happened later, there was growing uncertainty as to the level of the threat posed by COVID-19. There were concerns as to the unpreparedness of the public health sector, and of course an exponential rise in confirmed cases. All of these were mixed together, steered the government to turn into the tool as a viable solution, as a measure covering various gaps that epidemiological contact tracing, the traditional methods, cannot cover, both gaps of capacity and capability. And the authorization of the ISA to assist in the effort to thwart the pandemic created a legal framework for basically what is a data transfer regime. Data transfer regime between the Secret Service, the Shabak, ISA, and the Ministry of Health. The representative of the Ministry of Health did not have direct access to the tool. Rather than that, the Ministry of Health provided the ISA with identifiers of confirmed carrier cases, and in return, the ISA consulted a tool and retrieved a list of known locations of these carriers in the 2 weeks preceding to their diagnosis, and a list of whoever was in close contact with them. It should be noted that this repurposing of communication metadata for contact tracing may have 3 purposes. As I mentioned before, overcoming coverage gaps of classic in-person epidemiological investigations. We're talking about memory gaps, knowledge gaps. If I'm on a bus, I cannot remember who was around me, and even if I did, I probably would not will not be able to identify them. There's overcoming of capacity gaps. At first, the manpower only considerations. Manpower was lacking in the investigative unit for epidemiological investigations. So the tool operation, the operational purpose of the tool was viewed as a complementary measure to human face-to-face investigations. And there's another purpose that was not explored or explored very initially, is using metadata, location metadata, to enforce lockdowns and quarantines. You make sure that people are where they're supposed to be. The ISA refused to partake in any enforcement activity from the get-go, but at some point the police was doing it for several days. Moving on to the authorization creep, due to time constraints, I can't go into the gradual description of how it came about. But the first uses of the tool, and that's important, were without authorization. They were unlawfully. Two cases before even the most basic of authorizations were given. And this timeline, on which I cannot expand, highlights certain themes. First is the operational conception of the tool. It has narrowed down during that period considerably. At an early stage, the court struck down emergency regulations that authorized the police to use metadata for enforcement purposes. Later in the game, much later in the game, the court limited the use of the tool only to instances where it was required for coverage gaps in cases of refusal or inability to cooperate with in-person investigations. And this conception stuck also later on when the government wished to reauthorize the ISA to do contact tracing during the first week of the Omicron wave. A second aspect is the gradual introduction of parliamentary oversight. If at first ISA activities were done unlawfully, then they were done pursuant to emergency regulations that are initiated by the government. Later on, they were authorized through a government resolution that still is subject to an approval of a parliamentary subcommittee, hence more parliamentary oversight, and eventually, only later, it became a full statutory law. The court as a player there was both pushing to more parliamentary oversight, but it also enabled the ongoing ISA contact tracing activities by giving the government flexibility, more leeway, to start legislative proceeding towards an authorization law. So, function creep, or any other kind of creeps that I briefly mentioned above, did not start and end with the pandemic. We can see creeping trends nowadays in Israel. Either it's the function creep of personal information from, let's say, the civilian sphere or the private sphere to the security or public spheres, as demonstrated by a growing appetite of Israeli authorities to OSINT capabilities, to acquiring them. We can see also a purpose creep of surveillance measures from the national security domain, where they are already, most of them are contested, into the private civilian realm. This can be demonstrated by the growing use of spyware by the police, which is currently, it's an ongoing scandal for a year now, with the NSO Pegasus scandal in Israel. We can see it with the Israeli police eagerness to promote legislation authorizing the use of facial recognition technologies after these technologies were deployed successfully in the occupied territories. Do we see any instances of authorization creep now? Not exactly. What we see is a more blunt approach of establishing the facts on the ground, where the police make secret and unauthorized use of innovative surveillance technologies, which later on might be legally whitewashed if they get caught. This can be demonstrated again with the LPR system, Hawkeye, that its existence was revealed by the press nearly a decade after it was first deployed. And only following court proceeding, the police began to initiate a legislative process for statutory authorization. So, to sum up, the instances or dimensions of creep that manifested during this ISA contact tracing authorization affair are not unique to Israel, nor are they a product of the special circumstances of the pandemic. Creating capable, effective oversight mechanisms and establishing proper statutory safeguards may help to mitigate creep. And in my paper, I suggest several mechanisms that may do so. Thank you.
Thank you, Amir. Questions, please. No questions? It was a very informative paper, I have to say. There was a lot of information, and you left us hanging by saying, I propose in my paper. Please.
Just Thorsten Wetzling from Stiftung in Berlin. Amir, thank you so lot for enlightening us about Israeli practice. I know you've been researching this for quite some time. When it comes to the development of more legislation towards the end and parliamentary oversight, is the focus mostly on parliamentary oversight or also additional oversight, like judicial oversight in Israel? Thank you.
Well, there is not a lot of judicial oversight on these measures at this point. Whatever was developed throughout the pandemic was under a sunset clause. Even then, the authorization was not judicial but parliamentary. A parliamentary subcommittee had to approve a 3-week period in which the ISA may forward the data to the Ministry of Health. But we don't know yet what the government is going to do with the regular operations of the tool, but there is some draft in preparation. We have not seen it yet. We're waiting to see it.
Thank you. Yep.
Yeah, thank you for the great presentation. You said somewhere in the presentation, in passing, like, okay, it was not officially used, the techniques to enforce lockdowns and quarantines, except for the police. And then I wondered, in the Israeli setting, does the police itself have direct access to this tool of the security services? Or was this provided in the same way as it was provided to the medical health authorities? Like they had to submit stuff and then the ISA would respond like yes or no? Well, how did it work?
So the Israeli police does not have any direct access to the tool, although it would very much like to have it, naturally, like every law enforcement authority. Yeah. What they do is query on a case-by-case basis the telecodes. During the pandemic, there was a 1-week period when they were authorized to do it to enforce lockdowns, but rely on the same practices they do in law enforcement rather than the national security.
So they were not using the tools.
They were not using the tools.
Okay. Thank you very much.
A follow-up question?
You want to take it outside?
Yeah, no. Binding powers, oversight. Do they Is it in the works in Israel that if they find something to be unlawful, that they can say you should delete metadata or you should no longer transfer it to this agency? Is this on the cards?
Well, as far as I understand it, the metadata is either transferred live to the ISA or close to live in batches. I don't really know. So I'm not sure how much powers they have to order its deletion. There are allegedly, again, classified procedures on deletion of data, could be. We don't know much.
Well, then if I may, I have a question, more inviting you to explain to the audience a bit more about some of the suggestions that you said you have in order to overcome this problem. And actually it is interesting that all of us picked up and I think more people in the audience, even if they didn't ask the question, the issue of oversight. It's crucial.
Okay. What I was describing in the last part of the paper was the tendency of the Israeli police to adopt new technologies without asking anyone. Shoot first and ask question later, move fast and break things, any of those approaches. And we've seen in the US an interesting model, I don't remember the acronym, that's CCOps, something like that, community oversight procedures, where before purchasing or acquiring a new surveillance technologies, the community must be involved in the process. It's less relevant when you're talking about national security or high-level police acquisitions, but the idea of obtaining parliamentary approval with a due process and a risk assessment and maybe ex-ante preparation of procedures might provide a good way to deal with this acquisition of technologies without knowledge.
Which sparked another question, and that will be the last one in your time.
I'm crashing the party a bit because I was the legal advisor of the National Cyber Director of Israel.
Oh.
But I presented here about data protection regulation. So 2 short comments. One, the general framework, Israel has joined, or the OECD December 2022 declaration on access, national government access to, law enforcement access to data. So this is important, and now I'm not in government anymore because the executive and the Israeli government has said we apply these principles. And the way these principles are applied, of course, are part of the way that each executive agency, each government builds its system. Of course, more transparency is always needed. I think that one of the things that we've seen work in government is, as Amir mentioned, check legality in the procurement process. So you can't bring in technologies without checking them. And the other thing is have a statutory DPO. In suggestions for work I've done for the government, we've even talked about a statutory sort of oversight committee. So this would be not an ex-ante judicial review all the time, but it would have ex-post inquisitorial review to deal with this issue, because as you may be aware, if you're too transparent, the bad guys will know where to hide. Thank you.
Thank you. The big discussion about balancing when we give more transparency. So thank you very much. That was a very interesting paper and very interesting discussion. Thank you for the questions. The next speaker is Shrutika Gandhi, who is going to present a paper on FRONTEX as a hub for surveillance and data sharing, coming from a country from the borders of the EU. I'm very interested, and I've read the paper with great interest. Shrutika is a PhD candidate at the Institute of Advanced Legal Studies from the University of London. Her PhD research focuses on the human rights implications of the use of AI-based technologies for border management in the EU. She is also a teaching fellow in law at Queen Mary University of London, and previously she worked at the International Observatory of Human Rights as a researcher, focusing on the areas of freedom of expression, surveillance, and technology. You can stand here and present your work.
Hi, good morning, everyone. And today, yes, I will be speaking about the European Border and Coast Guard Agency, more commonly known as FRONTEX. So my paper examines how the role of FRONTEX has evolved from merely providing assistance to member states in controlling borders to carrying out high-scale surveillance using technologies like drones and running the European Travel Information and Authorization System, also known as ETIAS. that will grant travel authorizations to third country travelers based on automated risk assessments. So Frontex has undergone 3 major changes to its founding regulation, the founding regulation being the 2004 regulation, each one significantly expanding its tasks and powers. So the first major change in 2011 provided competence to process personal data. That was formally introduced in 2011. Then another major change happened in 2015, where the mandate of Frontex in relation to research, surveillance, and risk analysis activities was expanded to include direct participation of Frontex in the management of research and innovation activities, including the use of drones, advanced surveillance technologies, and information systems. So Frontex was authorized to proactively monitor and contribute to research and innovation activities relevant for the European integrated border management. And it was also authorized to monitor migratory flows using advanced surveillance tech, including space-based tech. It was also around this year that the Eurosur framework was adopted, which transformed Frontex basically into the EU's Border Intelligence Hub, Article 12 of the Eurosur regulation, giving Frontex the permission to coordinate the common application of surveillance tools. Then it's in 2019 that we see a massive jump in terms of its tasks relating to collection and processing of data and sharing of such data. Its role in relation to return activities was enhanced, and it is at this stage we could say that its transformation into a hub for surveillance, data processing, and data sharing was complete. So on top of the powers that it already had, it was now charged with developing and operating a centralized return management platform for processing all information that allows for automated transfer of data. It could share vast amounts of information, including personal data, with member states' law enforcement authorities, EU agencies such as the Europol, and importantly with the third countries with which the return operations were being coordinated. And another main task recently added into Frontex mandate was setting up and operating the ETIAS central unit. Now, Frontex would be responsible for drafting the special risk indicators or the screening rules, which will be based on the special risks that have been identified by the Commission, such as the risk of irregular migration and security, to name a few. These risk indicators would then be incorporated into an algorithm that will evaluate the personal data of applicants against the special risk indicators. And if the algorithm finds that the personal data corresponds with the risk indicators, it will trigger a hit, and the application would then be referred to the ETIAS national unit of the relevant member states. If no hit is triggered, then authorization would be granted automatically. Now, another key aspect of this paper focuses on how this expansion in the mandate of Frontex has not been matched with equivalent level of attention to protection of fundamental rights and having appropriate safeguards in place. Now, there have been serious allegations concerning Frontex's role in violating fundamental rights through its involvement in pushback operations, but the usage of drones and its surveillance activities have also been widely criticized, particularly by the EDPS and by the Fundamental Rights Agency, which have reprimanded Frontex several times from 2015 onwards. I wouldn't be going into details of those because I want to focus on the more relevant and recent challenges. Now, fundamental rights did occupy a center stage in the Frontex regulation that was amended in 2019. So compared to previous regulation, this regulation contained more than 200 references to fundamental rights. They were depicted as overarching components of the European integrated border management system. Frontex was charged with monitoring compliance with fundamental rights in all its activities, at the external borders and in return operations. Then references to data protection and privacy were made in the entire regulation, from attention to them in plans for joint operations to the technical and operational reinforcement provided by the border guards in their work relation to migration management. Now, despite these efforts, loopholes remain, and in the recent years, civil society has heavily criticized FRONTEX for sidelining data protection watchdogs and engaging in intrusive data collection from asylum seekers and sharing that data with Europol. An example of that is the investigation which was conducted by the Balkan Investigative Reporting Network, which revealed in November 2021 that Frontex's previous executive director proposed to expand dramatically the powers of Frontex, allowing the border guards to collect intrusive personal data from migrants and asylum seekers, including genetic and biometric data such as DNA, fingerprints, and photographs, information of their political and religious beliefs, their sexual orientation, and to store and analyze and share that data with Europol and security agencies of member states. The director also wanted to scrape social media profiles, all on the premise of cracking down on illegal migration and terrorism. Now, the investigative report claims that Frontex's data protection officer also strongly and repeatedly advised against such expansion and recommended that the EDPS should have been consulted. Those calls were, however, dismissed. And this has become a very serious issue now, upon which the EDPS recently commented as well and said that a full audit of these activities would be carried out. And several questions have been raised about this in the European Parliament as well. Now, moving on to the problems with ETIAS then. So the automated risk assessment contemplated to be carried out when the ETIAS system is enrolled poses significant challenges. It carries with it the inherent risk of bias and also interferes with privacy and data protection rights. Now, given the serious interference with human rights that are posed by these systems, it must be shown that such systems are not simply useful and desirable, but also meet the legal standard of being strictly necessary, as espoused by the Court of Justice in several cases, and more recently in the Lille PNR decision. So more specifically in Lille, the Court of Justice held that automated risk analysis and data processing interferes with the right to privacy, data protection, and confidentiality, and therefore such intrusions must meet the requirements of proportionality and necessity. And it seems that the ETIAS system fails to meet the strict proportionality and necessity requirement, as it does not sufficiently specify the purposes or the reasons for which large amounts and categories of data are being collected indiscriminately. And the ETIAS regulation states that it is essential for combating security risks posed by visa-free third country travelers. And one of the evidence that it provides for this is a risk assessment which was carried out by FRONTEX in 2016. But that risk assessment was ultimately not conclusive about the fact that these travelers were indeed security risks. And additionally, as per the API and PNR requirements, travelers are assessed prior to air travel, and hence it is not clear what is the added value of ETIAS in combating the risks on top of the already existing measures. These concerns were also echoed by the EDPS and the EU Parliament's Libe Committee. Significantly, the EDPS was not convinced with the evidence provided by the Commission supporting the necessity of using profiling tools for the purposes of ETIAS, and hence encouraged the Commission to reconsider the extent to which the use of profiling is necessary with the purposes that are to be achieved. Then another significant issue with the ETIAS system is the fact that the risk indicators would be defined by Frontex, and it enjoys a significant amount of discretion there. And the Ligue des Droits decision importantly held that the extent to which automated risk analysis interfere with the right to privacy and data protection depends on the predetermined criteria on which the algorithm is based. And in the context of ETIAS, this predetermined criteria would be the special risk indicators. Now, this discretion that Frontex enjoys is problematic because how a specific risk indicator is defined will have huge implications on how the algorithm will operate. And moreover, this highlights a wider transparency issue in that we do not know how the algorithm will be designed, as the special risk indicators factors are not specified in any regulations or legislative acts, and requests by various academics and civil society organizations for documents or clarifications on how the algorithm will operate have consistently been denied by Frontex. This additional task of operating ETIAS comes at a time when Frontex is already grappling with serious fundamental rights issues raised by its existing activities. Now, the rationale behind establishing ETIAS, its potential encroachment on privacy and data protection rights, and the enhanced power that Frontex will enjoy as the ETIAS central unit, advance a culture of treating migrants as security risks. And the increased cooperation between Europol and Frontex that is envisaged when ETIAS is fully enrolled will further blur the lines between border control and internal security, and hence promote this trend of migrants as security risks. Given the developments in the migration sphere, some of the recommendations put forward by this paper are that it is crucial now more than ever that the Frontex regulation is once again amended to address the deficits in its existing framework, and to take into account the recommendations that have been made consistently by the EDPS, by Frontex's own data protection officer, and by the Fundamental Rights Agency, which have been widely ignored. Frontex is facing significant challenges due to the expansion of its tasks and powers, and because of the politically strained situation that we find at the external borders of the EU, it is essential now more than ever that clearer guidelines are provided to address the shortcomings. And additionally, the European Parliament, as the watchdog, must continue to thoroughly scrutinize all aspects of Frontex's internal administration and border management tasks.
Thank you very much for this very informative information, paper and presentation. Thank you. And I would like to invite the audience to ask questions to the speaker. Yeah, please. Maybe you want to introduce yourselves. I forgot to say that before. That's better for the speaker.
Hi, I'm Matthijs. I'm a PhD student at Rabat University. And I've done a bit of research on the interoperability regulations before I started my PhD project, which was quite scary. And I think now, hearing a few years later on, that scare hasn't really been resolved yet, especially in fundamental rights. Thank you for your very informative presentation. I was wondering if, in the last few years, Frontex has ever been challenged in court yet. Like, has the European Court of Justice ever looked at these systems, ETIAS? Like, we know the PNR directive, but yeah, has there ever been a development in the judicial sense?
To my knowledge, not yet, but I feel that if the ETIAS regulation is not significantly scrutinized and amended, it is possible that a preliminary reference would be made to the Court of Justice very soon, like it happened with the PNR judgment. So not yet, but
fingers crossed.
May happen,
yeah.
Considering Ligue des Droits now. So, and because in Ligue des Droits it was a civil society organization that put forward it, we could potentially expect similar things to happen with ETIAS and Frontex's role in that. But yet,
we'll
nothing
wait.
really. Yeah.
It seems like it's time.
Yes.
Yes, thank you.
Absolutely.
Thank you, Matthijs. Just for clarification, I'm not sure if this was mentioned, but ETIAS is the European Travel Information and Authorization System. So that we are all on the same page. So any other questions? You referred several times to the EDPS and the role of the EDPS, and I have a very legal question. What is the relationship between the FRONTEX regulation and the regulation, the 2018-1725, the EU data protection regulation? Because FRONTEX is an agency.
Yes.
So what is the relationship between the two?
I think the relation between the two, as far as my readings is that, is that better? Yeah. All right, so in terms of what I have read from the regulations is that it always mentions the data protection regulation and that it will comply with it and follow it. But that's about it.
So there are no data protection provisions in the FRONTEX regulation?
Not
so actually we apply the EU data protection regulation, the one that applies to the EU bodies? Or are there also specific provisions in the FRONTEX that are complementary to it? I'm not familiar, so this is a very genuine...
There aren't very specific data protection regulations in the FRONTEX. It just mentions that we follow the EU data protection regulations which apply to all agencies, but that's about it. And that is also a significant point which the EDPS consistently raises, is that you need to have your own specific set of data protection rules as well.
Is this what the EDPS said?
Yes.
Because usually they like to...
I think in its opinion in 2018 it said that there needs to be a bit more clarity about what they are going to follow. And I think based on that, I think the FRONTEX also created this position of its own data protection officer in addition to a fundamental rights officer. But it's not clear as to, what the two are basically charged with and how the two interact with one another. But the DPO's role is very just, suggestive and like advisory role, but it doesn't really have to follow what the DPO says. And that was also one of the main concerns that, when I mentioned the Balkan investigative report, is like the executive director just consistently decided to not follow what the DPO was saying.
And you mentioned that the EDPS said that they are going to do a full audit of the practices, so shall we expect a similar approach to one, I would not say against Europol, but on Europol?
I would hope so.
There is a question.
Thank you for this presentation. I have a question which is maybe a bit broad, but in a lot of presentation, a lot of research that is conducted on the types of operations that you described in your paper, but that were also described in the previous paper, actually. There is a lot of very useful emphasis on what are the rules that should be actually respected by FRONTEX or different intelligence agencies. There's documentation of infringements and different, public law, constitutional law questions. What I'm starting to wonder is whether there is any research conducted or whether you're planning to do any research on the liability of executives in terms of criminal law. And I'm asking the question because about 10 years ago, the former head of the French internal intelligence agency, the DCRI, Bernard Swartini, was sentenced to a fine of 8,000 euros. Okay, it's not much, but still, he was held personally liable according to criminal law. And I'm also wondering, what is the criminal law liability of somebody who is at the head of a European agency? Is there any kind of immunity? How does this work? I'm not necessarily expecting a full answer because I guess maybe you haven't looked into that, but I was wondering if you knew of any research conducted on that, or if maybe that could be something for the future.
I think that would be a very interesting research topic. I'm sorry, but my research does not focus that on at all, especially nothing to do with criminal law. But yeah, I do feel that maybe that is something that should be researched and maybe looked into. Yeah, right.
Thank you. Bettina.
Hi, Bettina Behrendt, TU Berlin, Weizenbaum Institute in KU Leuven. I have a question that's really strategic. I mean, this is such a wonderful paper and such a clear message that many people will not want to hear. What happens now? How do you make sure that those who should listen hear your message?
I think if we just keep writing about it, if we keep talking about it, that's the best way to go forward. And like I said, like civil society organizations do have a major role to play around here as well. And they are doing a very good job of, making people aware about, the problems around the EU agencies, FRONTEX, Europol, all of them. And it is being listened to. Like the best example was the Balkan Investigative Report, which led to significant action being taken by the EDPS, by the European Parliament, where MEPs were asking questions to the Commission, holding them accountable as to, why was this under the rug? Why have we not discussed this? What is happening here? So I think the pressure is being put on these institutes that they need to comply, they need to, ensure that the regulations are amended and have those in place. And I think the key message is to go to the European Commission to now look into this, listen to what everyone else is saying, and actually go and make some amendments about this. But otherwise, it's just like the PNR judgment. It would go through the judicial route, but we know how complicated that could also be. But yeah, I guess the main way is to, continue to talk about it and keep putting pressure on the institutes. But, yeah.
I wish you much success. No, but I mean, I'm really asking for a larger reason. We're faced with that same question. What is the best way of getting these messages out to the right people? And therefore I was curious.
I think these conferences are a great forum for that as well, talking to other people, making sure the right people are listening. And like I said, civil society organizations really do have a very key role to play here as well. Thank you.
One last question.
Hi, my name is Uta. I work for the EDPS, but I'm here in my private capacity. Kind of just setting the record straight, the default option for FRONTEX, for any EU institution, is the EU DPR, so the specific rules applicable to EU institutions. There's some specificities regarding FRONTEX. Now to my question. You were already mentioning the fundamental rights officer present at FRONTEX. What are those specificities in the regulation? Have you looked into the role of that person? Have you tried to differentiate what happened with a DPO as compared to that fundamental rights officer?
I did look into the regulation, which did say that we are going to now have a DPO. But then, like I said, it wasn't very, very clear as to what is the remit of the fundamental rights officer and what additional is the DPO going to add. But I think in terms of the fundamental rights officer, it looks into the wider implications of FRONTEX's activities and their impacts on fundamental rights, such as non-refoulement and those kind of things, whereas the DPO is specifically looking into data protection related issues that FRONTEX may have while carrying out its activities, and also probably some of the privacy areas. But I think the fundamental rights officer has a wider role to play. But the similarity between both of these roles are that they are mainly advisory in nature. And I think that the main thing is to put forward an opinion, but whether or not the executive director of FRONTEX wants to go ahead with that is solely at the discretion of the director.
Thank you. And thank you, Shrutika, for this very interesting and informative paper. Thank you all for your questions. We will move on to the last paper. This will be presented by Audrey Dequesnes. She will be talking about data as electronic evidence in criminal investigations. Audrey is a PhD student in public law at the University of Lille in France. Her PhD topic is the French and the European Union governance of digital health. She is also research assistant for a Horizon 2020 project called X-Files, if I pronounce it correctly, aiming at the extraction of encrypted data from smartphones by law enforcement as evidence in criminal matters. She teaches digital health law and personal data protection to master's students, and I would like to invite you to present your paper to the audience.
Hello, and okay, you can hear me, perfect. And thank you for allowing me to make this presentation at CPDP conferences. So here we'll talk about the outcome of the research conducted within the European project H2020 founded, which is called X-Files. This project started already 3 years ago and will end at the end of June. So we already have done most of the work and achieved most of the tasks in it. Just to give you some context, X-Files is a technical forensic project about encrypted smartphones and more precisely the recovery and extraction of forensic information from encrypted smartphones by law enforcement. Is to understand that the innovative solution developed in the project is a combination of material and logical techniques, meaning that the law enforcement need to have the smartphone in their hands in order to operate it, and most probably will not be able to return it in the same condition, making this technique at least not the best for discrete surveillance and interception of communications, which is good for us because we can focus mainly on the legal framework for judicial investigations. It has to be mentioned that law enforcement agencies from 5 countries were part of the project. So namely France, Spain, Germany, the Netherlands, and Norway. And the UK was also part of the project but as an academic partner. So we have many pretty different legal contexts, plus some of the countries are member states of the EU and all are members of the Council of Europe. This project raised many questions about the right to encryption and fundamental rights, as the right to privacy and not to self-incriminate, for example, about zero-day policies, about the opportunity for LEAs to buy exploits for the private sector or the black market. And because many investigations happening in cyber context involve more than one country, the robustness of an evidence before a court of law is also one of the main issues. Depending on the context of the investigation, the states that are involved, the methods that are used, because one can be lawful in a state and not in another, leading to issue of admissibility of evidence. All that was addressed in more detailed matter in larger deliverables, but I would like to focus here on the cooperation between communication and internet services providers and the law enforcement. They evolve in different legal contexts, even if it's schematized to say that, but the law enforcement directive is on the one hand for the law enforcement and the GDPR and e-privacy directive on the other hand for service providers. So the law enforcement directive's material scope is limited by 2 cumulative conditions. The data processing must be carried out by the competent authority only for the purposes of prevention, investigation, detection, and prosecution of criminal offenses, or the execution of criminal penalties, including the safeguarding against and the prevention of threats to public security. As for the competent authorities, they can be public or private entities, providing that they exercise public authority on a member state's behalf. Despite the seemingly broad approach of the law enforcement directive, its actual scope is more limited than it appears at first sight. First of all, its scope is limited to the processing of personal data by competent authorities for the purpose cited above, that do not cover all processing of personal data in the context of judicial proceedings. Then it does not regulate the processing of personal data in the context of an activity that falls outside the scope of the EU, a criteria which can still be a bit subject to interpretations until it is clarified fully by the Court of Justice of the European Union. In this respect, the real added value of the Law Enforcement Directive depends on its implementation in national law and the willingness of national courts to ensure that the directive is applied uniformly through the EU. Another notable nuance is the fact that if providers of electronic communication services are not entrusted with public powers, even if it is asked for by LEAs, the collection or storing of communication data performed by them will not fall under the scope of the Law Enforcement Directive. Rather, it will fall under the scope of the e-privacy directive. Hence, if law enforcement agencies lawfully collect telecommunication data by themselves, this access does not fall under the scope of e-privacy directive, since the material scope of the e-privacy directive excludes law enforcement activities. However, access requests to the service operators remain a complex and particularly political issue, as even if it was not in the EU, but it's the most known case, the FBI versus Apple case, first demonstrated, like other that followed. Even in the EU in 2020, the stir that was created by an attack in Vienna was immediately followed by the adoption of a resolution by the Council of the European Union that seeks to oblige operators of encrypted messaging system to allow intelligence services to access content exchange via private privileged access. So for the sake of privacy, many voices have raised against this idea, but the balance is still precarious. To achieve the enhancement of cross-border cooperation, the European Investigation Order Directive is the mutual recognition tool used for cross-border requests relating to all types of evidence, including electronic evidence. Today, the current procedures for collecting cross-border evidence are governed by the said directive, which entered into force in May 2017. By replacing the old procedures based on the principle of mutual legal assistance, it requires all member states to trust each other's criminal justice systems. The European Investigation Order is based on mutual recognition, with orders flowing between and being executed by competent authorities with a number of non-mandatory grounds for refusal. In fact, the criteria used by country to grant or refuse requests from others are based on at least equally strict understanding of the powers of the authorities in charge of the investigation. Indeed, since each member state, when transposing a directive into national law, has the possibility of being more protective of the rights and freedom of the persons concerned, it can be thought that the most restrictive provisions of the LEA's power, and therefore the most protective of fundamental rights, will be mechanically favored. But we found out that it is not always the case. And although there are different admissibility criteria at national level, the execution rules are less strictly applied in the context of cross-border exchange of evidence than when national authorities conduct a national investigation. Even if member states develop protective national legislation, studies show that it is not strictly applied in the context of evidence that is gathered abroad, either because some member states have not adopted specific national provisions of the admissibility of evidence gathered abroad, or because some have more flexible approach to the use of such evidence. As a result, member states take different approaches to the issue of admissibility of evidence from foreign countries, which may involve the following. Relying on lex locus legislation and use the foreign requirements for admissibility of evidence, rely on the lex forum legislation and use the same model of scrutiny that is applied to evidence gathered at the national level, limit the national model of assessment only to general principles such as legal order or fundamental rights, or because of the gray area, ignore the foreign and domestic model of assessment and automatically recognize the evidence as lawful. So, contrary to our first hypothesis, the scenarios do not particularly favor the defense's rights. So, as briefly said earlier, the analysis showed significant lacks of coherence, discrepancies in the way the law enforcement directive has been transposed in the various member states. The phenomenon creates a first barrier to lawful exchange of evidence with inequivalent frameworks for data processing in investigations. The second barrier is the framework surrounding data retention and the duty of cooperation of telecommunication service providers, either communication of metadata or content data, as both can be personal data and very useful for investigators. Not all studied states have the same provisions in their legal framework, nor do envisage the same eventualities or provide with the same level of precision in their positive law. But it is to be noted that each national legislation of the country studied in the project have provisions. National laws in the EU member states provide for different retention periods for metadata retained by electronic communication service providers, which also vary depending on the purpose of the retention. For example, in France and Spain, where there is a legal obligation to retain metadata for law enforcement purposes, the metadata retention period for traffic, identification, and location data is 12 months. However, in 2020, the Court of Justice of the EU issued two very important decisions on data retention and ruled that member states could not impose a general and indiscriminate obligation on electronic communication service providers to collect and retain traffic and geolocation data. However, several EU states continued to require such collection in order for law enforcement agencies to access it. As a result of this almost exclusively case law framework, it has been noted that the different interpretations by member states of the case law of the Court of Justice leads to a fragmentation of practices regarding the collection and retention of connection data. One solution to this problem could be to harmonize the duration, conditions, and type of data collected by the member states. Analyzing this disparity in the international framework that seems globally harmonizing thanks to the Budapest Convention and its additional protocols, for example, we interrogated the effect of that fragmentation on the fundamental rights of individuals. So more recently, the Court of Justice of the EU extended its reflection and considered that the obligation of general data retention by operators could only be provided for if it is temporarily limited to what is necessary, justified by a serious threat to national security that is actual, present, and foreseeable, operated under the effective control of a judge or an independent administrative authority whose decision has a binding effect. The scope of the rulings has been interpreted differently in member states. The mainstream practice regarding the retention period obligation remains 1 year, notably in Germany, Spain, and the UK. Nevertheless, this obligation is discussed in the Netherlands since 2014 case law in a position that is more favorable to the respects of privacy, while in France, a judgment of the Council of State of April 2021 considered that the generalized retention obligation is now justified by an existing threat to national security. Furthermore, France wishes to maintain the possibility of retaining such connection data to a greater extent than said by the European Court of Justice, not willing to comply with the conditions set out in the 2020 judgment. So we identified some of the legal discrepancy that you can see here. Okay. Is it right? Okay. Already almost done. But the debate is also fueled by reflections on cooperation mechanisms and their evolution. A study on the retention of electronic communications non-content data for law enforcement purposes has reported that the European Investigation Order and the 2000 Convention are the strongest channels for the exchange of non-content data for most of the law enforcement agencies. But the excessive length to obtain the non-content data, as well as the lack of harmonized rules and the lack of knowledge of other states' data access practices, threatens and makes it difficult for law enforcement agencies to obtain this data from other states. However, these procedures are renowned as slow, especially compared to the fast pace of cybercrime and cyber-enabled crime. And for this reason, the European Commission, at the call of the Council, has proposed a new framework for access to electronic evidence, which no longer requires going through the LEA of the country involved, but directly requesting access from the service provider if it is in another state, allowing access to the required data within a much reduced time frame, and which is 10 days. In this, sorry? Okay. Yeah, okay. It's I'm at the conclusion. So even though this directive is still under negotiation, we can foresee important changes in the current legal framework. So to conclude, the lack of common minimum rules, the variety of national norms on the admissibility of illegally gathered evidence, which has created a very fragmented and set of rules, increases the complexity of the use of transnational evidence. This situation not only jeopardizes the effectiveness of international judicial cooperation, but above all, the effective protection of fundamental rights. Which means that a lot of work is still required on that matter, despite the relatively recent law enforcement directive, and the law enforcement should not be the only stakeholder that is pushing for it. And before thinking about new pieces of legislation, the correct enforcement of the existing one would be significant progress for LEA, for EU citizens' rights, and for service providers, as they are sometimes trading on eggshells on that matters. And just as a final word, okay, that's not an issue. I would just like to remind that the law is not here to prevent law enforcement agencies from pursuing crime, but it is already a balance that has been made between various rights and that we need as democratic societies. Thank you very much.
Thank you. Are there any questions? Please, you can.
I'm a legal researcher at CPDP, KU Leuven. Thank you for this presentation, and I was wondering whether Court of Justice of the EU expressed any position on this fragmented national legal framework and the admissibility of evidence, not only collection and transfer, but did it say something about the admissibility issue as well? And if not, how do you see the role of the Court of Justice? What would be your suggestion about the way in which the court should act? Thank you.
About the Court of Justice, I feel that they are kind of pushing in the right direction for the preservation of fundamental rights. I don't know if I can. Maybe you want to precise your question, or maybe I'm not reminding it.
So basically, you mentioned the court cases from data retention, and I was wondering if you have seen any cases that specifically focus on admissibility, which is, you said, a more national law issue, normally not an EU law issue. And if you haven't, I mean, it's possible that you haven't seen such a case. Do you think the Court of Justice should be more proactive on that, should rule more on an issue that is normally regulated at the national level?
Okay, thank you. The issue is that even if even if decision have already been taken, it's very different between each member state. And if you, for example, have an issue between two, it will not solve the case between two others. So yes, I think we need to have more global rule about that, and I hope it is going to.
If I may, in the end of your presentation, you referred to the evidence regulation, the proposed evidence regulation, which is actually answering your question. We don't expect the Court of Justice to just randomly start. They shouldn't, if you ask me. And how, if I may, if there are no other questions, I wouldn't like to take the time from the audience. How do you see actually the evidence regulation solving the problem? That's exactly the problem that the evidence regulation is trying to. Have you looked into this? We have the proposal of the European Commission. We have now a position from the European Parliament. They are moving to a concrete direction. Is this something that would solve the problems that you presented, or do you think we need a completely different new regime or different rules or whatever?
What is very complicated, I think, is that criminal matters are very national competencies, and it feels a bit odd to have a global EU regulation that is that precise on that matters.
Is not about, just to clarify, the regulation is not about the criminal matters. The regulation is about the problem that you highlighted, the accessing of data for law enforcement authorities from private companies. And there is a panel, I think, just now next door.
Yeah, and I think that is very positive, because it can help reduce the uncertainties about that, and that is crucial, I think.
Thank you. So,
thank you.
I don't think we have time. Do we have time? No, we don't have time for more questions. You can take them outside during the break. Thank you very much. A big applause to the speakers.